Welcome to this traffic safety webinar sponsored by the North Carolina Governor's Highway Safety Program. This is one in a series of webinars addressing topics of interest for traffic safety professionals. The series is co-hosted by the Institute for Transportation Research and Education at NC State University and the University of North Carolina Highway Safety Research Center. Today's topic is Standard Field Sobriety Tests and Drugs, Hit or Miss, presented by Tara Jenswold and Emily Thompson with the Wisconsin Department of Justice. It's my pleasure to welcome Sarah Garner with the North Carolina Conference of District Attorneys, who will introduce Tara and Emily. Sarah?
Thank you so much, Eugene. Y'all, Tara and Emily are my friends from Wisconsin, and they perform the same function that I do here in North Carolina. They are traffic safety resource prosecutors. Tara has been a TSRP since 2003. An assistant attorney general, which is the functional equivalent of an assistant DA here in North Carolina since 2009. Emily has been with the Department of Justice since 2016. And for 9 years, she was a prosecutor in Dane County, Wisconsin, which I know is Madison, Wisconsin, because that's what my birth certificate has on it, is Dane County, Wisconsin. Anyway, they do pretty much the same thing that y'all see me doing. They give technical assistance, they try cases, they deal with expert witnesses, they help prosecutors with motions to suppress, attacks on cases. They pretty much are an all function. You need help with impaired driving, they help with impaired driving. They also handle vehicular homicide cases and give assistance to prosecutors there on those issues. They do a lot of trainings up in Wisconsin for prosecutors and for law enforcement officers, and I'm really excited to have them work with us today in North Carolina. One of the topics that comes up a lot is SFSTs are fine for alcohol, but do they work on drugs other than alcohol? And the answer is a resounding yes, and they're going to explain to you why it does and help you with these attacks that we hit in court all the time. So with that, Eugene, shall we carry on?
Thank you, Sarah and Tara and Emily. If you'll go ahead and share your screen now and begin your presentation.
Well, thank you, Sarah. You can tell that Sarah is a really good Wisconsin girl because she has the same accent that Tara and I have.
Yeah, we're just like Sarah, but we don't have the great accent. So hi, everybody. I think we got a great introduction, but we want to introduce you. I mean, it's not every day you get a couple people from Wisconsin talking to you. If we were in person, we could share some of these delicacies. Well, not the cows, but with you. But unfortunately, we're not. So you're just going to have to look at pictures. And the pictures don't do it justice. But here are some things that we offer in Wisconsin. And so we thought we'd expose you to this. We've got, I know when we were starting the webinar, Eugene thought up in the upper left corner that those were tots, but they're actually fried cheese curds. And so if you haven't had those, and it's not the same as fried mozzarella, you guys, it's fried cheese curds. You have to experience those. And if you come to Wisconsin, and obviously they've spread to other places, but they were originally here. We also have cows. We are the dairy state. We have bratwurst, which doesn't look quite as appetizing there, but they're delicious. We've got lots of great beers we like to drink here. And so the New Glarus Spotted Cow is one of our feature brews here from a little local brewery. Of course, the old fashioned, we prefer brandy in our old fashions, although you can do bourbon or other forms of whiskey. And then in the final photo in the far right corner, those are cheese curds. Those are fresh cheese curds. They squeak if they're especially fresh. And so that is also something you want to get when you come to Wisconsin. So that's our little introduction before we get to the serious stuff. Also, you know, there are times when you realize that your state is just as people would think it would be, which is something like this happens. And just last week, this was a headline in a county up north where these cows did in fact stop a police pursuit. And so this is a real headline from June 1st.
You guys think that you have cows and that you've seen cows. That's great. But our cows fight crime. And so they help us with our, investigation and prosecution of traffic cases.
Yes.
Obviously, and all of these cows will be witnesses in the eluding case.
All right. So with that, we're going to move on to the topic of the day, which is, do the fields work? Are they hit or miss when it comes to detecting drug impairment or indicating drug impairment? And so, a spoiler alert here, people use drugs and then they drive and they are impaired. I know that's shocking, but they do in fact do that, as some of our favorite movies here depict. The Pineapple Express, Big Lebowski, Cheech and Chong, there were a plethora of options. But I know it won't come as a surprise to you guys that people drive after using drugs. And that they drive.
Tara, I thought that was Dazed and Confused.
Oh, maybe it is. No, I think it's the Pineapple.
I don't know. I haven't seen Pineapple Express.
I think
so
it's the
I don't
Pineapple
know.
Express. All right. So, and the numbers also show that, but then again, we don't need to be telling you guys that because you're on the road and you yourself experience this. But just in January of this year, USDOT indicates, and we've seen these numbers from the pandemic, how obviously less drivers, but more dangerous drivers out there. And the drug impaired drivers were also included in this. Not surprisingly, the prevalence of marijuana increased about 50% in drivers, and opioids as well.
And this could certainly be with, the way that people were dealing with the pandemic and the isolation of the pandemic. Maybe a lot of us, went to the store in our pajamas, whereas we might not have also always done that. And, maybe people felt more.
Yeah, some of us, ate ice cream and some used opioids. I mean, you never know.
Potato, right?
Yeah. All right.
There's a lot of meth in Wisconsin also. So this is kind of a fun graphic, although old, and it does show that there are a number of states who have per se limits for drug driving, and some states have zero tolerance laws for drug driving. I'll let you know that since 2017, our law has changed, and now we're just like Pennsylvania here in Wisconsin. We've got a zero tolerance law for many drugs, including our Schedule I drugs and some others, and a 1 nanogram per milliliter per se law for THC. That's Delta-9 THC. And looks like you guys are also per se tolerance for some drugs. So we definitely have some things in common.
Yeah, and as we understand it, obviously, our accent gives it away, and of course, our slide demonstrating all that we have to be proud for or of in Wisconsin, but we're not from your state. But as we read your statute, because we are lawyers, we know how to read the law, it looks as though you guys have a per se law for Schedule I controlled substances, and it looks like marijuana is down far on the schedule as a Schedule VI, from what we could tell. But it is interesting, and when we consider the fields and their usefulness in drug impaired driving cases, to know, what our laws are with respect to that.
International laws they also have per se limits in some places and zero tolerance for some drugs. But it seems that, even though it's kind of all different in every different sort of specific place, there are a lot of similarities. We all have operating while impaired laws. We call them OWI. So I know you call them DUI. So OWI might kind of slip out of my mouth or Tara's mouth during this presentation at some point, but we all have our own impaired driving laws. Prosecutors have to prove impairment under many iterations of these laws, but if there's a per se limit or something like that, like a PAC for drugs, then we don't have to. And part of the reason that it's so across the board in terms of what our laws look like, state by state and country by country, is because we don't know exactly what amount of each different drug is going to impair every single person. And of course, it's going to be different. I mean, even if you just look at marijuana, the studies are showing that that people can be impaired at many different levels. There are, the most popular, I think, per se level for marijuana in the US is 5 nanograms per milliliter. And there are several studies that say that that's frankly too high, that people can be impaired at levels below that. And so then prosecutors have to work under an impaired driving law rather than under the, I guess, somewhat easier to prove per se limit law.
So obviously, whether we have a per se law or not, which you in your state have some iteration of it, and we have it in ours as well, and ours even specifically included Delta 9 THC until recently it went to 1 nanogram, which is obviously low. But the bottom line is we still have to prove impairment. Now, it could be we're going forward on a straight per se offense, but that is rare. Usually, at least in our state, and I imagine in yours, if they're exhibiting impairment, we're going to charge with the impairment charges as well as the per se offense. Or if it's not a drug that's subject to the per se law, you're going to have to prove impairment. And so, as Emily said before, we've got to go forward with impairment. And so how do we prove impairment? And one of the ways that you all know we do is through the SFSTs. And I specifically chose this clip from, or this little meme, whatever it is, from Bridesmaids, because Bridesmaids was supposedly taking place, or supposed to have taken place, in Wisconsin. And
so we do the field sobriety tests in Wisconsin.
Yeah.
Mm-hmm.
And you know how it is when you watch shows that are involving your profession. Like, I'm not ashamed to say I watch Law and Order all the time. And I feel like they're usually realistic, but I could not, Bridesmaids is such a funny movie, yet I could not get past the fact that the trooper had like the wrong patch on, and he didn't look like a trooper, and the car looked wrong. And well, anyway, occupational hazard, I guess. Anyway, with the field. So we know generally, whether we're talking about drugs or not, there's all sorts of challenges you guys have seen. And, I'm sure Sarah and Ike and the folks in North Carolina have given you all sorts of great training on common challenges to the fields. Here lists several of those that we have. And obviously for today's purposes, we're going to talk about the challenges specific to, they don't work for drugs. They miss the mark. Things like the SFSTs are only validated for alcohol. And that's what the studies originally validated them for. That's what they were designed for. We'll address that. They're just not really relevant to the issue of drug impairment because there's really no studies or research kind of tying it into, they weren't validated or created for that purpose. Talking about some of the studies that come out. And in the context of this discussion, we'll talk a little bit about the science, the expert testimony, terminology, things like that. But let's dig in. So the claim here, not surprisingly with the title, it is the defense bar who thinks that the SFSTs really missed the mark when it comes to drugs. And what do they rely upon? Well, first, let's talk about why we care. Obviously, in your specific case, if you get a challenge to the fields, some sort of pretrial challenge where it's a suppression issue, where they don't even want you to be able to talk about the fields, we care because it affects the evidence in your particular case, right?
The less evidence that is heard by the jury or the judge at the trial, the better it is for the defendant. And if you've got evidence of clues or even other observations during the course of the field sobriety tests, during the administration of those tests, then that's information, if they can get it excluded, that doesn't get heard by the jury. And it can lead to an acquittal for sure.
And not surprisingly, the cases where we see challenges like this pretrial, where they want to exclude the fields, are cases where it's relatively close, right? Maybe you don't have a whole lot of other evidence supporting your, impairment. And so it really is significant that you get, if the fields are suppressed. And so clearly it affects your specific case. But then beyond that, there is, a slippery slope. We are not going to be able to create separate field tests for any potential drug or combination of drugs. And so that is not something we want. And Once we start going down that path, what we don't want also is case law that tends to treat drug DUIs or OWIs. I think we like OWI just because it allows us to really showcase our Northern accent with that long O.
Oh, geez, it's an OWI, yeah.
Oh, anyway, we digress. So you don't want case law where not just in terms of the fields are different for drugs or alcohol, but we've started to see this in other cases, where the defense bar is trying to get the courts to see drug OWIs differently from alcohol DUIs in terms of, do you have probable cause? And can you have the blood tested for all substances? Or if, because you're, suspecting alcohol, can you only have it tested for alcohol? We recently saw it in our search incident to arrest case law, where the defense bar wants the courts to basically say, if an officer suspects alcohol impairment, they may not search in the vehicle for other evidence, indicating drug impairment. So in other words, they could only search for alcohol containers and not smaller compartments with drugs. And so the bottom line is, we don't want this separate two-tiered system between alcohol, and drug DUIs. And also, the more limiting they get, the courts, you don't want to threaten or compromise your ability to testify to your observations of impairment or be able to give that opinion ultimately of impairment. Before we go on any further, I want to say, because I forgot to at the beginning of the presentation, oftentimes, and we as TSRPs, we beg, borrow, steal from our counterparts. And in this PowerPoint, we did that. We did use a lot of helpful information from our counterparts, Dina Ryerson in Oregon and Ashley Shook in Wyoming. And so I wanted to get that out there. I also wanted to say that this is the only slide that we put in there exposing you to our awful winter weather, because we wanted to keep it light.
This is an actual picture of my driveway, except for the mountains, I guess. So what are the defense relying on when they try to make these divisive statements, to draw these lines in the sand between drugs and alcohol, OWIs, and to do this? Well, I mean, there are some studies they can use. There are some studies that are kind of equivocal. There are a lot of studies out there about drugs and how they show up in different people in different SFSTs, and they don't all have the exact same conclusions, turns out. So they can rely on some of these studies, and they can rely on the confusion created by the number of studies that don't all have the same results in order to kind of sow confusion among judges, which of course is a tactic. And then of course there is some case law, because there's always a little bit of case law on pretty much every topic.
Well, and we know how it works, right? So some defense attorney somewhere gets lucky and gets a judge to buy his or her argument, and even better yet, an appellate court will buy that argument, and it can be in a completely different state. And of course, that's not binding on our states, but all it takes is a little momentum and a little ammunition, and the defense bar collectively, whether it's your state or nationwide, jumps onto that. And then they have that as ammunition to, launch these attacks.
And the vast majority of judges are not, have never been trained in law enforcement. Some have been prosecutors, but not a lot. And so there's really a lot of opportunity to get judges on board with the defense bar and make some, in our opinion, bad law.
So one such study recently, and why this has become an especially hot topic, and this happens, periodically, is this NIJ study. And sometimes now I'm not saying with respect to this particular study, but I feel like when we're talking about studies, we should do the air quotes, because there is great variation in studies. And I'm not saying that that's what's going on here, because I think this is by and large a good study with some good information. It's just been misrepresented, which is one thing we want to talk about when we address some of these, the basis for some of these claims by the defense. So this one was published just in April of this year. And I know this drew quite a bit of attention, at least among the TSRPs, and some fellow TSRPs did some really helpful summaries of what went on. And so Emily, do you want to talk a little bit about this NIJ?
Sure. What it comes down to is this article came out, which is essentially summarizing this study that was done by the NIJ. And the NIJ is a legitimate organization. They don't, represent the defense or any of that type of thing. But when you look at the headline of that article that from April, it says that the SFSTs are not reliable indicators of marijuana impairment. And then if you look at the byline to the headline, it says essentially that blood THC levels don't correlate with intoxication as felt by the subjects or impairment as exhibited on the field sobriety tests. And obviously, when you look at the title of the actual document itself, the actual study, what they were studying was differences in impairment, and that's impairment, subjective impairment, and objectively observed impairment, and then measurement of that impairment, both in testing and in field sobriety testing and substance testing due to route of administration. And so they studied a group of people who either vaped or ingested orally cannabis. And they dosed them specifically. And they found that that these one leg stand, walk and turn, and obviously HGN, we're not going to see that in the vast majority of cannabis impairment cases, that those three tests were not sensitive to cannabis intoxication for any of the substance for the study participants. But they also did, well, I mean, I guess we'll talk about the limitations to that test in a minute. One of the limitations.
You want limitations, Em?
No, we're fine. Let's talk about this stuff first. And then they also determined that when people used cannabis, that cannabis use decreased their cognitive and psychomotor functioning, which is in a way what we're looking at when we're looking at field sobriety tests. And so even when they had low levels of THC in their blood, and what I'm talking about is kind of what I alluded to earlier, those same studies that showed that people exhibited signs and symptoms of impairment at levels of THC, levels of delta-9 in their blood at below 5 nanograms. That's exactly what they were looking at here. And that's exactly what they found here. And then they also said that the SFSTs that are commonly used, obviously because they're standardized, to detect impaired driving were not effective in looking at marijuana intoxication. So they did say some of these things, and in my opinion, like I had a hard time reading the study and a hard time reading it because I felt like reading the article too, because I felt like there were some things that were missing. And there really are a lot of limitations to this study. And so if you are faced with this in court, or you are in a case where the prosecutor is faced with the study in court and a challenge to the field sobriety tests on this basis, then this is something that should be, whoever is the proponent of this study should be cross-examined about this. So first of all, there was a low number of subjects that were used in this study. It was 20 individuals. They were brought back for 8-hour days of testing for 6 weeks in a row. So they did 8-hour, like every Sunday for 6 weeks or something like that. And it was the same 20 people every time. Now they had them so that they weren't, they all said that they hadn't used cannabis in the 30 days prior to starting the study. So supposedly they don't have a high tolerance, but you never really know exactly. Second one is that we don't know who it was that was administering the field sobriety tests in this case. The document itself only says that researchers administered the field sobriety tests to the subjects. And so who are these researchers? It doesn't say that they're trained police officers. It doesn't say that they're DREs. In fact, I hesitate to believe that they are. I don't think they are. So their familiarity with the field sobriety tests and whether or not they're even certified to administer them is an issue. Another one is that they gave baseline tests. So they, when the people showed up for their 8-hour day, they did all of the tests baseline. completely sober at the beginning of the day prior to dosing. And then they dosed them. And then they run them through the test every hour until their 8 hours were done. And then they did sample testing at the same time to determine levels. And so, first of all, we don't do baseline in real life. So we don't know how people perform on the field sobriety tests when they are sober versus after they've been dosed. And the second issue here is that once you practice these tests a few times, you get to be kind of good at them. And so by the time they're on the third, fourth, fifth, sixth week of this study, these people, by the end, they've gone through field sobriety tests a minimum of 46 times each. And so by that time, they're like, oh yeah, I know this one, walk in a line, 9 steps, short choppy turn, there we go. I guess we don't say short choppy, we say a series of small steps. But at any rate, it's not really mimicking real life in any way, shape, or form. And so the way that these tests are administered, it just doesn't look like real life. And there are other tests in which it does, other studies in which the administration of the test really does look like real life because it was done in real life.
The other, some of the other limitations that we see pretty frequently in the studies, or especially those that are put forth by the defense, is that they're only focusing on the validated clues. And so it's as though the arrest decision or the decision about, ultimately it would be in real life when you guys were using them, it would be about the arrest decision. But the decision here about whether or not the fields are effective is conditioned just on the observation of the validated clues. And so all the other things that you take into account, of course, all the totality of the circumstances and the observations you make and other things, observations that you make that may not rise to the level of validated clues aren't accounted for in this determination or in these studies. And, the bottom line is they're just not realistic conditions. This is an extremely small subject, class of subjects with 20 people. And so, it really doesn't tell us much more than we didn't already know. And especially those folks in states that have legalized marijuana have seen, which is, it really is hard to, equate performance on the fields with a particular, level of impairment. We know that. But what also came out of this is they didn't say that the fields were not effective or that it would lead officers or people to be arrested, officers to arrest people who were under the influence of cannabis. Instead, what it would do is, if anything, it would have the opposite effect, which is saying that the fields aren't sensitive enough to detect people who are under the influence of marijuana. And so if anything, it would miss people rather than, include people wrongly, in other words. And, at the end of the day, it also did say that there was impairment shown on the fields. And so, it isn't really, I think the bottom line here is it's not really what the defense touts it to be in terms of, oh, just like that study invalidates the use of fields for drug-impaired drivers.
They weren't even really studying how the fields worked in marijuana cases. That wasn't really even their focus. It was more on the method of administration and how that compared and whether people were impaired at different levels based on whether they vaped it or whether they ate edibles.
There were some useful findings that, we, from the state prosecution side can use and take away from the study. And so, there's always positive. And again, this isn't that the NIJ study was a bad study. It's just not what it first appears to be or what the defense would tout it to be. And certainly not what the headlines, those initial kind of headlines that they came out with would suggest. So I think, that's sort of the latest ammunition that the defense bar has and what we likely would see. But I think it illustrates, there have been lots of studies that are critical of the fields or critical of you as officers relying on the fields in drug-impaired driving cases. I think, the discussion over the limitations, I think this is something that is worth underscoring. We've got to look carefully and take a really close look. We have to accept the studies introduced by the defense with a grain of salt, and really look close at those and make sure, we can't take the defense's word for it. And we definitely have to make sure that a court doesn't get snowed by the defense's presentation of it. Okay, so in the we just got a question. In the NIJ study, what was the cognitive component to the study? I couldn't find the actual study to review.
I'm going to look it up.
Now, Emily, wasn't this the one where there was, or was that a different one where there was the little tapping device?
Yes. Oh, are you asking like what it was that they were?
Yes. What was the, yeah, I think that was the question.
So
what is the cognitive component?
They had people do some math, like a couple of different math type tasks. And
gosh,
they had people,
all of us lawyers would fail that field sobriety test. Can you imagine if you guys had to have people do
I'm
math?
glad I get to show my app. So then they had this app called Druid, D-R-U-I-D, and there are 4 different tasks on here. And so the first one is tap the squares and circles. And so it's see a square, tap where you saw it, see a circle, tap the oval. And then it'll show you this.
Did you pass the math component?
Oh, I didn't do the math. Oh, see, I'm doing it. I'm doing really good.
I can't see anything.
Oh yeah, there. Anyway, whatever. But it has you like tap on the screen and do these various things. And then there's one where you have to follow the circle with your finger, like a circle that moves, and count the number of flashing squares that come up. Which is kind of divided attention-y, because you have to look at 2 things at once and do something with your body while you're doing something with something separate with your brain. So in a way that's kind of neat, but I got to tell you, in the study and in that article, they don't even mention those tasks at all. They don't mention the math task. They only talk about field sobriety test performance. And so either they are lumping all of these things together and saying that they're all field sobriety tests, or they, didn't come up with anything that they wanted to report that didn't include the SFSTs.
All right. So we talked about what else does the defense rely upon? And we've seen it before. It looks like, and we were able to, Sarah sent us some of your most relevant case law, and it looks like you guys are very fortunate. We thought we were fortunate in Wisconsin with our favorable case law, but it looks like you guys really have, between your expert testimony rule and allowing you to testify to the DRE protocol and HGN, and your case law, you've got some really great law on the books. But what happens, as I said before, is that we can get a case from a completely another state, and that really tends to pick up momentum and is used across the country, even though it's not binding precedent. It can be relied upon, and lots of times when there's no other case law to rely upon, a court in one state will rely on an out of state decision. And so this Gerhardt case is the one that probably has garnered the most attention, the most significant, out of Massachusetts in 2017. And it dealt with whether or not an officer could testify to marijuana impairment, and specifically could testify to the admissibility of the fields regarding, marijuana impairment. And, what happens then is, and I know Dina Ryerson in Oregon ended up having a Gerhardt challenge in Oregon that she handled. And I'm sure, other states, especially those that have legalized, have seen similar challenges. But, what we get out of Gerhardt, and I won't spend a lot of time on it, is just a couple things. One, the court was clear that it felt, and this is what we talked about before, it seems courts really buy into, the more studies there are, the more muddy the water becomes, right? And so the court in Gerhardt said, listen, there's no real consensus as to whether or not the fields are helpful in determining or detecting marijuana impairment. And without, a clear consensus, we, have to err on the side of not accepting that it's, that the fields are necessarily reliable in terms of determining impairment. And so the court actually says that, Here, ultimately, what the court rules, though, is the fields may be relevant. And there's this distinction which we start to see in you as officers, whether you're testifying as lay witnesses or expert witnesses. And the court in Gerhardt reminds officers and prosecutors there that an officer testifies as a lay person when he or she testifies to things like balance, observable conditions, balance, coordination, ability to follow directions, ability to, perform divided attention tasks. And that is lay testimony because those are things that are within the general understanding of the public. A couple limitations, though. The court said here, and we've seen this before, and I'm not sure if you guys have been dinged with this. We are not. We don't have case law that says you have to refer to them as roadside assessments. But here in Gerhardt, the court said in Massachusetts, if officers are testifying in a marijuana DUI, that they have to refer to the fields as roadside assessments. Now, thankfully, here the court within the decision said, we recognize we're not going to be able to completely eliminate the term tests from officers' vocabulary because, this would be really concerning for us as prosecutors and you as law enforcement to have to be worried about, am I accidentally going to say test? Because that's how you're trained, right? And so that's what we've always known them to be. And so the court in Gerhardt did note that, which I think obviously was with an eye toward, we're not going to declare a mistrial if an officer accidentally slips up and uses the term test. But nonetheless, you get this limiting language. You can't testify to pass or fail, which of course is what you shouldn't be doing anyway, and hopefully you're avoiding that. And the court says you can't testify that the performance on the fields led you to believe that the person was under the influence of marijuana, which of course you also wouldn't do because you would never just base your opinion on the field test evidence alone. So in a lot of ways, not really telling us anything we don't know, but emphasizing that there are limits and you've got to know your limits. Here, the court says, a lay witness cannot give an opinion that another person is high on marijuana. And I'd be interested, this was 2017. It seems that is now perhaps within the general understanding of the public nowadays. And so I'm curious if other states who have legalized, Colorado, Washington, have if the courts have taken a different view, because it would seem that with the more people using marijuana, the more familiar and more within the general realm of understanding it would become. But nonetheless, in Gerhardt, the court said, a lay witness could never testify that another person was high on marijuana. I think I could because I have had teenage sons, but here the officer couldn't do that, not qualified as an expert either to do that. And, the stay in your own lane, I mean, this is something we talk about a lot. We typically don't need you unless it's a DRE, but we don't need officers necessarily to testify that a person is, what substance the person is under the influence of, because we have toxicology to do that. And so when we say stay in your own lane, just know what your limitations are, do your job. You lay all the impairment out and statements, and of course, there's probably going to be an opinion. You're going to know based on your training and experience what the person is under the influence of most likely, but let the toxicologist and the toxicology itself speak to that. And then obviously we put that before the jury. You can always testify as an officer or as a lay witness to your personal observations, right? The appearance, behavior, demeanor, all those other indicators of impairment. And it's not, really the Gerhardt decision and other similar decisions aren't that concerning because while it may be frustrating because you as officers have enough training and experience to be able to do it, jurors, are smart. We put all this evidence that, you give your testimony, we put in the video evidence that demonstrates all this physical and mental impairment. And then we argue that to the jury and they connect the dots. And so we don't necessarily need, you to make the leap for us. But case law, that's, another way, that gives them the ammunition they need, and then the challenges start occurring. So what can we do to respond to the challenges? And we talked a little bit about this, but let's get into it a little bit more. And I think it starts with kind of getting back to the basics. And, you go back to your training and your SFST training. You go back to the original studies, and we're going to talk about the ways in which the original curriculum and some of the original studies are inclusive or supportive of you using the fields in drug cases. First, let's just really break this down. Why do you use the SFSTs in your DUI investigation? And we know they're divided attention tasks. This is Emily's favorite cartoon.
This is totally my son. He is all
right.
about but for him, it's the iPad. He's like, oh, I'm working. It's awesome. But obviously, field sobriety tests, as part of your training, as part of your experience, these are divided attention tasks, just like driving. And just like that, following the white dot with your finger while you're looking for the yellow squares type of thing. It is, driving is a complex task that takes your mind and your body to concentrate on different things, or your mind to concentrate on a couple different things. You got to watch the road ahead of you. You got to watch your mirrors. You got to be careful of your acceleration, of your braking, steering, all of those things. Also, what direction you're going and whether you're warm enough, and whether your passenger is talking to you. And, there are a million things that are going on in your brain at the time that you're driving.
So breaking it down, we all know this, and I think those of us, who do this as prosecutors and law enforcement, it's just such a no duh moment. Like, yeah, they're divided attention. But I think, explaining this to a jury, and in terms of being able to defend the use, not that we should have to necessarily, but we are, right? Defend the use of fields when you're trying to determine whether someone's under the influence of drugs is getting back and breaking it down to the most basic. And that is, you're looking at it, the person's ability to divide their attention between various tasks and relating that. We see it right here in the manual, and you guys know this, although I will say, I think sometimes officers struggle with, and we hear defense attorneys saying, well, how does it, why does it matter if my client can stand on one leg? How is that relevant to driving? That has nothing to do with driving. And so the manual here provides some really good language about that. And also this is helpful to get us back to the beginning and to the basics when we're talking about why are these field tests relevant and helpful in determining drug impairment. Specifically within the manual here, is that discussion of the same mental and physical capabilities as a person who has to drive. And Emily mentioned these, that information processing, vision, small muscle control. These are all things that, coincidentally are also affected by somebody when they ingest drugs. And so it's good to break it down and go back. Right within the manual here, these are psychophysical tests. And so here, when they describe within the manual, that section 1 and section 7, there's mention of alcohol or drug impairment. And so they're, kind of when we're going to focus on the manual itself, yes, they were originally created to detect alcohol impairment. Yes, they were validated for alcohol, but the curriculum itself incorporates drugs and detecting drug impairment in many different places. And when we're talking about the very basics of what are the field tests, right here within the manual, section 1 talks about drug impairment along with alcohol impairment. Again, more really useful, and we can share this PowerPoint information in here that in different places that talks about how not just alcohol, but alcohol and many other drugs reduce that ability to divide attention. And that's why these psychophysical tests are so helpful. I guess I didn't even really realize this, and so it was good to delve back into it. We hear so often in court, well, these are really hard tests. In fact, when I was just looking online to get, I can't remember what I was looking for in the last couple of days with this presentation, I saw so many defense attorney websites that, what the police don't tell you about the tests is no one can pass them sober. And of course, we hear those arguments all the time in court. And so it's interesting to me, and this slide came from our counterparts, Dina and Ashley, that right within the manual, they talk about how simplicity is the key to divided attention field sobriety tests. These are reasonably simple tests for, the average person to complete as instructed when sober. And so this was great language to find, not just for combating the challenge to using the fields and drug DUIs, but also just generally when you hear, the defense attorney claim, well, nobody can do these sober. These are great excerpts from the manual that would be awesome to be able to counter those claims with. So, more specifically, what they're going to say, the defense attorneys are, the fields aren't validated to detect alcohol impairment, or that they're only validated to detect alcohol impairment and not marijuana and other drugs. But, in response to that, there are, even in the original studies, contemplation that people would be under the influence of other drugs. And so we won't spend a lot of time on these, but Emily's going to briefly just point out a couple points because we're going to run out of time.
So the first study was the Colorado validation study that was done when the PAC or the BAC across the United States was 0.10, if you guys remember those days. But then the San Diego one was done in 1998 and Florida was done in 1997. And those two are the ones that are more relevant to drug impaired driving, because drug driving was certainly on the rise after that initial validation study. And that's when the BAC increased, or the PAC decreased to 0.08. And the San Diego study took into account the fact that, what they were looking at is they were looking at field sobriety tests, the validity thereof for 0.04 or 0.08. And they concluded that officers' estimates of whether a driver's BAC was above or below 0.08 or 0.04 were found to be more than 90% correct. But they determined that factored into that was the fact that people might have something else going on in their blood. So they might have a 0.05 BAC, but they might also have drugs on board. And they took into account, really for the first time, the fact of polydrug use, which of course is something that happens all over the place. And so they looked at, I can't see the whole slide, but at any rate, this is, it was an initial acknowledgement that drugs can also impair a person's cognitive abilities and balance, and that can also be reflected, those factors can be reflected in their performance on the field sobriety tests. And when you look at the Florida study, which was done just even sort of near to the same time, slightly before the San Diego study, in there they looked at, obviously they looked at PACs of 0.08 or below, but they acknowledged that the three main field sobriety tests, or the standardized field sobriety test, had been incorporated into the DRE protocol, and that they were used as part of a DUID determination and not just an alcohol impaired driving determination. And so they're looking at impaired driving as kind of one big cohesive thing and not separating it into alcohol impaired driving and drug impaired driving. But as I'm sure is the case in your state as well as in ours, alcohol is still the #1 drug in impaired drivers. And so because of that, these validation studies ended up focusing on alcohol because that's what they found in people's blood. But even, what were we going to say? Oh, even
I was just going to say, no, you go ahead.
One more thing.
Okay, yes.
Even in the Florida study, they determined that only looking at those 3 field sobriety tests, trained officers will be 90% correct or more in their arrest decisions. And I feel like when you're looking at drugs, it is more, because one of the things that they did, they chose that in this study, they determined that correct arrest was based only on a person's BAC. They didn't even do testing for drugs. But they went on and acknowledged that subjects might be impaired by other substances. So the decision to arrest made by the officers might have been even more right.
So I think, our point here is just that looking even at the original studies that validated the 3 test battery for alcohol impairment, there are indicators and certainly relevant information to take from those that supports using the test to look for drug impairment, whether or not they're validated, they're still valid and useful. And we can find support even in the original validation studies of the fields. And I think it also larger, kind of the bigger picture is that it speaks to this progression, right? It has evolved, the fields have. And so of course, initially it was alcohol, and that's why they were developed. But we see, and the Florida study is, illustrates this, that they're eventually, the fields are incorporated into the DRE protocol. And so that evolution is really apparent throughout these studies. And now we continue that evolution today. So the initial studies themselves can be relied upon for us in combating these challenges. There's also other studies, a lot of them specific to applying the fields in marijuana cases. And if you want to just briefly touch on these.
Well, these ultimately, this is a 2-year study, and they looked at real life cases. And so when we talked before about how the one study looked at a real super controlled environment, here they looked at cases that have already happened, compared DRE evaluations and police reports with blood test results, or I think it was just blood here. And they looked at everything, including the driving behavior, including the field sobriety test, including the other indications of impairment, trying to find a correlation between blood THC levels and impairment. And they came out to say that field sobriety tests are sensitive to impairment by marijuana. So in that, they can determine whether, a person's balance is affected by the marijuana they consumed, or that their ability to function cognitively is impaired by the marijuana they consumed. However, there's no direct correlation between SFST performance and a level of THC in the blood. And so that's actually not a super surprising finding, given all of the other things that we know about marijuana impairment and how it varies between individuals. And there's another study from 2016, from the same year. And in this one, they looked at 302 real life DRE cases, and ultimately determined that impaired people did show physical effects. And this is what DREs have known for years. People who are impaired by marijuana have a increased pulse, an elevated blood pressure, dilated pupils, and that there really isn't, they also noticed that there wasn't a difference in performance on the field sobriety tests, really, based on that, the plus or minus that 5 nanogram THC level. And then they found that if 2 or more of certain factors found together, if you have 2 or more of those, that individuals were found to have impairing amounts or amounts of THC in their blood in 96.7% of cases. So that is a super, super high amount of cases. And those are listed here on the slide as those 3 or more finger to nose misses, on the modified Romberg balance test, if they had eyelid tremors. Now, going back to that initial study that we talked about that said that SFSTs were not good for showing marijuana impairment, they did do the modified Romberg, but they didn't look for eyelid tremors, and they didn't appear to note that in any of the study or materials. So eyelid tremors on the modified Romberg, 2 or more clues on the one-leg stand and or the walk and turn. So those can certainly show impairment, and that is definitely stuff that we're looking at. And obviously you'll note that HGN isn't on this list because, as we already said, you're not going to see HGN in the majority of THC impaired individuals.
So, there are studies, to counter, for every study the defense can bring up in support of this claim that, the fields are no good for drug impaired drivers. There are plenty of studies that provide us with useful findings and useful conclusions that the tests actually are helpful, and we can rebut those claims. In addition to, we're going to run out of time here, but in addition to the marijuana specific cases, there's all sorts of other studies out there that talk about other drugs. One in particular, just to give you a quick alert, and we won't spend time on it because they're going to present on it. at the DRE conference is a study done in Michigan. Tom Page was involved, and Wes Evans, I think that's his name, one of the DREs there. And again, you know, the value in these is that these are real life conditions, looking at real cases. Here again, these are police officers who are trained to administer and evaluate the test, who are doing these studies, and that's where their values, you know, really can be found. Like I said, they're going to present that at the DRE conference. Says, though, that they're useful in detecting impairment from drugs other than alcohol. So that's the underlying conclusion there, and that's helpful to us. But there are limitations. One is, right, Emily, that they only collected urine, and they can explain that at the DRE conference as well. But you know, there is still useful findings. Here's a bunch of others, and we've included these in the PowerPoint. And again, the bottom line is there really are several studies to counter any defense claim. And while it may be that, you know, yes, they're not validated, but there is a difference between validated and valid. You can still have these, the fields be valid indicators, useful tools for you in determining whether someone's impaired. And in fact, I think, you know, it's irresponsible for you as law enforcement and, you know, not to do the fields to determine what, you know, whether there is impairment and what the potential source of that impairment could be.
Mm-hmm.
So
other studies have looked at SFSTs for people using amphetamine, people using MDMA, people using prescription drugs like trazodone. I'm sure this is just a smattering of studies. I'm sure there are more out there.
So, you know, one thing, we're going to run out of time here, but, you know, it's important that once you're in court, you create a record. One thing that we should say is, you know, as law enforcement, this really isn't something, you know, unless the defense is specifically challenging the use of fields and brings up those challenges, whether in a pretrial motion, you would know that, or your prosecutor would let you know. But unless the defense is going to cross-examine you on some of these other studies and counter your testimony and basically cross-examine you by saying they're not effective and you shouldn't be using them, we were, you know, you don't need to get into, you know, playing defense right away, right? You don't need to get into the studies, and you don't need to necessarily introduce new studies. I think this is one of those things where, you know, if it's not broke, right. If it's not broke, don't fix it. I was gonna say, if it's
that's right. Yep, that's it.
Yeah, whatever. So in any event, you know, creating the record is important because, you know, if these cases are going to go up, you guys have, like I said before, really great laws right within.
I don't have this.
Yeah, I don't know of many states that codify, you know, right within the statute allows you to testify to HGN and DRE, which is super cool. You also, Sarah provided some really great case law that you guys have. And so it seems like in North Carolina, you guys really, like much of the hurdle or many of the hurdles that we face in other states, you guys have some really great statutes and favorable case law as to, you know, this was a 1974 case that is allowing an officer with 5 years of experience to testify to someone, you know, being under the influence of drugs. And so that is really helpful, and also probably, you know, cuts a lot of the defense arguments off at the knees. With that, we're gonna, as I said, run out of time. One thing to kind of remember, and I think we walk this fine line with you as law enforcement, you know, doing fields, you know, you have specialized training and knowledge. We want to showcase that. You obviously deal with far more impaired people. But I think one of the things to remember is that oftentimes the defense makes it much more complicated than it really has to be. And, you know, jurors do understand. It's like what we talked about before with marijuana becoming legal. It seems more and more people know, just like with alcohol impairment, what people under the influence of marijuana look like. And, you know, unfortunately, that probably is the case in some areas with meth, with opioids. And so, you know, keeping that perspective, it's not rocket or weird science necessarily, and let's not overcomplicate it. And at the end of the day, the bottom line here is impairment is impairment. And so what you're looking for from an officer perspective, you don't know until that tox result confirms it. You don't know what substance is impairing somebody. And, you know, you don't know that until toxicology confirms it. And so you're going to use every tool in your tool chest to determine what is causing, you know, this impairment. And At the end of the day, that's what matters for you. We'll have other evidence to prove, what it is that, what substance is in the blood. But impairment is impairment from your perspective. And we'll share the PowerPoint. There's all sorts of references within the manual to, impairment is impairment, right? You conduct your OWI investigation or DUI investigation the same. You don't care whether it's drugs or alcohol. You're going to go into vehicle in motion, pre-arrest screening, contact with the defendant. And so it's one in the same, basically. And we apologize for running a little over. We've not ever had to give this entire presentation like this. I also want to apologize because this this graphic, until I got it up and showed it full screen, this end sign apparently has some graffiti on it. It says, "I will not end this love."
So we will end this presentation.
We will not end this presentation. So, all right.
Aaron, Emily, thank you
everybody.
so much
Yes,
for a great and information-packed presentation. Sarah, while we're waiting for any questions to come in, and let me just say, as Tara noted, we are at the end of our scheduled time, so if folks need to drop off, we understand. The recording will be available. We'd like to give anybody a chance to ask a question, either raise your hand or put it in Q&A for a moment before we close out. And Sarah, while we're waiting for those questions to come in, do you have any follow-up with Tara and Emily?
No, I just, not a question, but I agree completely. One of the things I think that we end up in court doing is getting absolutely bogged down when the defense attorneys come in and toss out, "Oh, well, it was just for alcohol. It doesn't count on drugs." And what you both are saying is absolutely right. It's common freaking sense. If you look different, you are different. And, one of the things that I think is important to stress to officers is, even if you're not seeing the classic signs of alcohol impairment, which now is getting to be sort of child's play because we're also used to it and juries and judges are used to it. While you're doing these other tests, be looking for these other signs and symptoms, be looking for the body tremors, be looking for the trembling eyelids. They don't have to be the specific clues that they are looking for with walk and turn one leg, stay in HGN. It can be other things that also are important. But if you haven't been through ARIDE, if you're not a DRE, it's very, very important to make a notation. I don't know what I'm looking at, but I'm looking at something that's not normal.
Mm-hmm.
Sarah, will you be able to, I don't think we gave it to you, but will you be able to share our PowerPoint, or how do you want to?
Absolutely.
Awesome.
Yes, it's all been recorded, and I think
oh, that's right.
Yeah, I would assume that it's probably in PDF form too. So if anybody's got any issues with it, just send me an email, and and I'll make sure that you get the information. But it's been very, very useful. Y'all did a wonderful job, and I do like cheese curds. I can't help it. It's genetic.
Yes, and Tara, I just wanted to add, if we'll get a PDF copy of your slides from you,
Awesome.
we'll post those to the Traffic Safety Conference website right next to the link for the recording. So folks will be able to view the recording and download a PDF of the slides.
That would be great, since we committed like the ultimate faux pas by speakers. I hate when you run out of time, and so sorry about that, guys.
No, you did great.
Too excited about.
Yeah, I would like to point out that all of us Wisconsinians are blondes, and and we do talk alike.
Yes, we do. Yes, we do.
Well, we don't have any questions in queue or hands raised, so I'm going to go ahead and wrap us up here. I'm going to switch over back over to my slides to close this out. And again, I want to thank you, Tara and Emily, very much for a great presentation, and also to Sarah and to everyone who joined us today. If you do have questions, take a moment and go ahead and submit those, put those into the Q&A, and we'll forward those on to Tara and Emily and Sarah to get a response to you back by email. And also, before you leave, feel free to use the Q&A window to share any suggestions to help us improve the webinar series, including any future topics that you'd like to learn about. So as I mentioned, following today's webinar, you'll receive an email with the recording link. So be sure to watch for that email. Also in that email will be a link to request a webinar participation certificate if you'd like to have that for your training records. So just click on the link that's in that email to request a certificate, and our admin will email a PDF of that to you. Please note, however, that only attendees in the live webinar may receive a certificate. So if you happen to be watching the recording of this right now, we're unable to award certificates just for viewing the recording. We want to invite you to join us again for other traffic safety webinars that are planned for this series. So please visit our website at the link here on the screen for a listing of the upcoming webinars. At this same website, you'll find information about our next North Carolina Traffic Safety Conference and Expo, which is planned for next August, not this coming August, but next August. So we do hope you'll plan to attend that conference, and we definitely invite you to propose topics for presentation on the website. There's a link for presentation proposals. Just click on that and submit any ideas you have. And with that, I want to thank you again for participating in today's webinar. And goodbye for now.
Thank you.